Today we're going to talk about licensing, and this is the 1 hour in which we get to learn how to make money, more so than in the other parts of our course. Licensing is not well understood by a lot of people, even in the business. And so we're going to hope that maybe by the end of 50 minutes from now you'll have a better understanding of what licensing is all about and why it is that some people have difficulty with licensing. Let's first discuss the concept of licensing. It's an agreement not to assert one or more of the exclusionary rights that you get in a patent against the licensee. You can have a patent license, and the rights that are exclusionary for patents are to make, use, sell, offer for sale, or import. And you can license either or all or any of those rights together or selectively. And you can license them with regard to a specific territory if you wish. You can also license trade secrets. And a trade secret right is to use or disclose to others while it's secret. Licenses can be exclusive, where only the licensee and the licensor, only the licensee can use an exclusive license and not the licensor. They refer to sole licenses as licenses that only the licensee and the licensor may use. So a lot of people think about granting an exclusive license to somebody under their patent, and they don't realize that that would then exclude them from using it themselves once that license has been granted. So if you want to retain the right to use your own patent or trade secret, you would like to use a sole license if the person you're dealing with wants some measure of exclusivity. Non-exclusive licenses are where anybody that you want to license can get a license, and there's no limit as to the number.
Quick question.
Yes, question.
Can you help me understand how you might license a trade secret?
Same way you license a patent. Somebody wants to make a project or process or use a process that you've developed. They don't know how to do it themselves because you've kept it secret. You could license them under the blueprints, the know-how, the vendors, if it's the sources of materials that you have, if they're not generally known. In chemical processes, oftentimes the details of the processes are secret and can't be discerned from reverse engineering the products that are produced by the chemical processes.
So would you basically tell them how to do it then?
Yes, under written materials that have marked on it, confidential, do not disclose. And so then they would become privy to those secrets, and they would then use those secrets with the promise that they wouldn't tell anyone else, and that they would use reasonable efforts to maintain those secrets in confidence. The patent licenses have a risk if there is a link of the patent grant to other business dealings. A patent licensor generally cannot condition the grant of a patent license on a requirement that the licensee purchases an unpatented commodity from the licensor. And the classic case has to do with Morton salt, where there was a patented machine that used salt, and in order to get a license under the machine patent, Morton required them to buy all their salt requirements from Morton. And the court determined that that was improper. The patent was issued on the machine, and you can license the machine however you want, but you can't require the payment and the purchase of an unpatented product along with that. You're not supposed to use the leverage of the patent to get some other exclusionary right. So you have to be somewhat careful if you have a patent that you're granting a license under, that the license terms are limited specifically to the rights that are appropriate for coverage by the patent. You can sometimes have other antitrust risks if a party with a dominant market position becomes an exclusive licensee. If you own 60% or more of the market, the antitrust laws present a barrier to you acquiring further exclusionary rights by purchase because they do not like monopolies generally, and they don't want people to use their exclusionary power, their market power, to get further exclusionary rights. So you cannot grant an exclusive license under your patent to someone who is a dominant player in a market for fear that you'll have an antitrust problem. An implied license is one which is presumed by law. You don't actually have to have a written agreement. They don't actually even have to say, I hereby agree that I have a license, or I hereby grant you a license. One who purchases a patented product from a licensed vendor has an implied license to use, repair, and resell the product, but not to reconstruct or modify the product. So that happens automatically whenever you buy something at a store. If it's covered by a patent, you presumably yourself get a license that comes with the product. And that license is only good for that one product. And it doesn't allow you to reconstruct that product or modify that product. It only allows you to use it as it is, or to replace parts that normally wear out rapidly with replacement parts. A patent license can begin before a patent is filed, and certainly before a patent is issued. A lot of patent licenses are negotiated when a patent application is pending, but you can even have a patent license negotiated before the patent application is even filed. And there's no constraint on the front end as to when that patent license can begin. On the other end, however, a patent license cannot extend beyond the term of the patent unless it is part of a collection of patents, and then it cannot extend beyond the last to expire of the patents. Trade secret license can begin immediately, and it can last forever, because trade secrets don't have a term. Trade secrets, in theory, could last forever. In some cases, the license can continue after the trade secret becomes public. And I mentioned the Listerine case. The person that invented the formula for Listerine mouthwash had quite a bit of early commercial success, granted a license while the formulation was secret to a company that wanted to make it themselves. They signed the agreement saying that they would pay royalties for the formulation. There was no patent involved. It was just a formulation under a trade secret. They agreed to pay royalty on the formulation. And a few years later, somebody took the product, reverse engineered it, and published the formula. So the formula was no longer secret. Now, most often, when you have a license under a trade secret, the terms of the license provide that when the secret becomes public, the obligations to pay terminate. But in the Listerine case, they didn't have that provision, and the court determined that they had to pay royalties essentially forever under that formulation, because that was the deal they had agreed to. And so that's something to think about. If you have a trade secret license that is not linked to a patent, then you'd want to make sure that you wouldn't have to pay royalties if, through no fault of your own, the secret becomes public. Combined patent and trade secret license, which is what you see most often, generally cannot extend beyond the term of the last patent to expire. There are public policy reasons for that. You just are not supposed to do that. A license agreement is assignable by the licensor, but there may be restrictions on assignment by the licensee unless addressed in the license agreement. Typically, a provision is included so that the licensee has the right to assign the license along with the sale of the related business. Unless expressly granted, Non-exclusive licensee has no right to grant sublicenses. Just because you get a license doesn't mean that you can thereafter give that right to somebody else just like you got it. You are limited to it yourself personally for non-exclusive licenses. Licensees often include a grant of a right to have made without the right to sublicense, allowing the licensee to take title to products made by a third party, a private label manufacturer, before reselling them, but not giving them the right to actually grant a sublicense to that third party to sell direct without the title passing through the person granting the license. Now, sometimes in licensing agreements there are provisions that include the rights in improvement inventions made by the licensor relating to the licensed invention. Other times, licenses require a grant back of improvement inventions made by the licensee, with the right of the licensor to thereafter sublicense others under the improvements made by other licensees. If not expressly provided for, a later made invention is not a part of a license agreement. Issues of fair valuation and personal liberty are often present with improvement rights provisions. And I see this from time to time, particularly where an engineer is doing some consulting work and he's working on a particular project, and the person wants to have an assignment of any improvements that the engineer makes along with the project that he's been assigned to work on. And oftentimes the engineer says to himself, well, I'm only going to be doing this kind of project for this customer, so I'll be happy to grant him any improvements that I come up with in the future. But then what happens is that if he has success with that engineering project, other people want him to work on other projects in that same field, which might be considered an improvement. Then he's stuck with that agreement that gets in the way of his ability to do further consulting. So I would generally advise people to be very careful about any grants of improvement rights in connection with a deal that they make with any engineering project. And furthermore, it's really hard to determine whether or not that improvement will be worth a lot more or a lot less than the underlying invention. And so it's very hard to determine the valuation because we don't yet know what that improvement's going to be. Till that improvement is made, you can't assess the value. It could be incredibly valuable, that later improvement, much more important than the original design that you've done. Or it might be of very little value, in which event you can gift it to the person as a part of your good spirit of cooperation. But that's a tricky point to keep in mind if you're ever working on a deal for a consulting arrangement. Now, what we're going to do from this point forward is we're going to do a theoretical calculation. One of the things that people have in mind is that for a particular license there should be some standard rate that is industry designed, industry adopted, that there should be a reasonable royalty that everybody would know in this field. What would a reasonable royalty be? And that's sort of like saying, I have a piece of real estate, what's it worth? Just tell me what real estate normally sells for. Well, I need to know how big it is. I need to know how close it is to an interstate highway exchange. I need to know whether it's on campus or in the middle of a swamp. I need to know a whole lot more about that real estate before I can determine, have any idea. There may be a large container of oil 30 feet below the ground where a filling station used to be that's leaking into the groundwater nearby, and if you buy that property, you then are subject to a huge liability. So it may have a negative value, in fact. I don't know of any case where a patent license would be negative, but I do know of cases where a patent license should be zero because the alternatives to that which was patented are better, less expensive to make, and therefore a reasonable royalty in theory should be zero. So you cannot, based upon any looking at comparables, tell very much about what a patent license is worth. You really have to look at each situation as a unique situation and figure out from that unique situation what it is that is an appropriate, reasonable royalty. And I've got a formula here that you can go through to get a ballpark figure on what a reasonable royalty would be. The Court of Appeals for the Federal Circuit has determined that this formula is not a very good formula to use. But the Court of Appeals for the Federal Circuit has no simple way to figure out what valuation should be. So I would suggest that this would be a really good formula to use for ballparking what the dollar value would be for a license. So the first thing that you have to do is the same thing you do in real estate, is find the closest, most effective alternative design which does not require a license. In real estate, if you're looking at a house, you try to see what comparable houses are in the area and what they've sold for recently. Now here, because each invention is unique by definition, there is no comparable to that invention. But there are comparable products in the marketplace. And there are comparable products in the marketplace, maybe not as good, presumably, because the patent should be on an improvement, but there are comparable products in the marketplace that do not require a license, or if they do require a license, you can put that license dollar amount in the calculation of the cost. And then you compare that alternative design that avoids your patent to one that's covered by your patent. Now this may bring to mind homework 2. So one of the parts of homework 2 is to design around a patent, and the other part of homework 2 is to come up with an improvement to a patent. The part of homework 2 which is to design around a patent claim is what you will typically be faced in the real world where other people have patents. The part of homework 2 that is to come up with an improvement that falls within the patent is what you will typically do if your company owns a patent and wants to further its business based upon the patent. You want to make further improvements, but you'd like to have the protection of the patent you already have to help protect that marketplace. So comparing alternative designs with the invention is really an essential element of determining valuation. And then you look at the economic differences. Let's say this alternative product that's the closest design around that you could come up with cost $1 a unit. And suppose you made a dime off of it. Well, if your invention can be marketed equally well at $1.20 and you can make 30 cents off of it, then you're going to make 20 cents more because you have the invention. And what you do is you divide that by 3 to get a nominal royalty. Generally speaking, an inventor is entitled to about 1/3 of the advantage that the invention brings. And the company that actually takes the product to market, that manufactures it, that takes the risk, generally is entitled to 2/3. That's a ballpark. People have argued it's 25% or 40%, but most of the time it comes in around 1/3 of the economic differences. Now this is not 1/3 of the profits that you're making. This is only 1/3 of the delta between the profits that you would make with the invention compared with what the profits you would make with the closest prior art alternative. And then you need to make some adjustments for all kinds of reasons, and we'll go through how it is that you might need to make adjustments on special circumstances. Sometimes, even though you got your patent from the patent office, you may have learned of a new piece of prior art that puts into question whether that patent should have issued. Maybe it was a really clear case when it issued, but now that you've seen this new piece of prior art, you're not quite so sure whether it would have made it through the patent office again. In that case, you might want to discount that 1/3 difference somewhat. There may be a risk of unenforceability. Maybe you entered into an agreement where you tied the patent to the buying of salt, for example, and now you realize that that's a problem, and so even though you've terminated that agreement and you've tried to repair things, you might want to lower your royalty rate because of that misuse of patent risk that you might have. If the grant is exclusive, almost always you'd have a higher percentage, because the person that has the exclusive right is preventing you from licensing anybody else. So you have to get more from that one person to justify the grant of the license. Sometimes you adjust based upon unique industry practices, and each industry has its own way of looking at things that tend to influence whether royalty rates are high or royalty rates are low. And generally, it correlates to how many patents are there relating to each product that the industry sells. If there are large numbers of patents on each product that the industry sells, then the royalty rates tend to be a little bit lower, because each person in the industry wants to establish that the royalty rates are low when they might be charged with infringement from somebody else. And because there are lots of patents relating to each product, there are lots of risks of third parties suing them for infringement. In particular, the automotive industry and the consumer electronics industry tends to have relatively low royalty rates simply because there are lots of design alternatives to design around patents, and because it is in the best interest of each of those companies to have low royalty rates, because the name of the game is low cost in getting market share in automotive and in consumer electronics. The inverse is a pharmaceutical company. Pharmaceutical companies generally have a single product, and when you have a single product, there's generally one patent, or at most 2 patents that you might need in order to license that product. There's an enormous investment in getting regulatory approval to market the product, and so in those cases the royalties would be very high, tend to be slightly larger than you would otherwise calculate by this formulation. But this is a ballpark to get you close. And lastly, as in all negotiations, you have to adjust based upon a special need to do a deal. It may well be that you're trying to license your patent and you really want to get 5% royalty. The other side only wants to pay you 3%, and you are 3 months behind on your car payments. They're about ready to foreclose on your house, and you're saying to yourself, 3% doesn't sound too bad, even though I've calculated that it's worth 5%. On the other hand, if you have a business that really needs a patent to fit an array of products, if you have a void in an array of products and you really need that, you might pay more than the calculated royalty in order to fill that void, to have a unique product that will sometimes open doors so that you can then sell your other products once you get in with your unique product. So it works both ways. Sometimes if you're really in financial trouble, you will accept a lower amount, and sometimes if you really need it to get entree to other customers, you'll pay a little bit higher than this. So you have these fudge factors that modify somewhat what the calculations would be. And the second thing that you do, now you've calculated the dollar savings in terms of the differential in profit. You've divided by 3, and so the next thing you have to do is convert the valuation to a royalty method. Now, the reason why you don't ever put in your license agreement a payment based upon profits is because any good accountant can make those profits come out to whatever he wants to make them come out to be. And so it is of no confidence in knowing that you will be fairly compensated if you base a royalty on profits. So you calculate the profits, you look at the profits, you do your analysis in the realm of profits, but when it comes time to fix the royalty, you convert that generally to a percentage of sales. And you standardize on that percentage of sales because the accountants can't fudge their sales in terms of dollars nearly so well, and they really can't fudge the number of units that got sold. And because those are not fudgeable, that's really what you want to base your royalty on. So the first thing you do is analyze with profits, then you convert it so that it's based on a percentage of something that is easily determinable. Percentage of gross sales less return is the most common. Royalty rates vary widely. I personally have had royalties as low as 0.01% and as high as 60% of sales. And each case is unique based upon the specific situation. The 0.01% related to a consumer electronics product and a patent that had pretty clear design alternatives to it. The 60% related to a product used in the manufacture of cottage cheese, concentrated Streptococcus diacetylactis bacteria. And that provided a 60% royalty on the sale price of that bacterial concentrate because it made such an enormous difference in the flavor and shelf life of cottage cheese that it was easily worth the 60% of its sale price for a royalty. And that royalty stuck throughout the term of that patent. Per unit sale is the other way to do it. There are some inventions that really don't link to the dollar value of what's being licensed so much as they relate to the unit. If the unit is sold, it doesn't matter too much how much the unit sells for. The added value is about the same. Whether it's a gold-plated unit or a tin-plated unit doesn't make any difference. So there, you generally just say so many dollars per unit, and then you almost always put in an inflation adjustment to that dollars per unit so that you can keep up with the loss of the value of dollar over time or the increase in the value of dollar if you happen to have deflation. And lastly, there is a sneaky thing that happens when you have cross-licensing. And this gets back to what I talked about. Different industries have different perspectives on things. Sometimes in an industry, and particularly the consumer electronics business comes to mind, the parties actually want to establish low royalty rates for their patents because they want it to look like patents are always licensed at a low rate. And so you might have a Panasonic licensing 50 patents to Sony and Sony licensing back 150 patents to Panasonic, and they have this massive cross-licensing arrangement. And they say, my 50 patents are worth 0.75%, your 100 patents are worth 1.1%. And they do that cross-licensing deal, and they're both very happy because their prices of the products stay low, they're not having to pay a lot of royalties, and they're making it look to all other comers as though patents in this field are not worth very much. And so it's to their advantage when you're doing a cross-license to forget the economic realities and try to sort of send a message more so. Because it's all a wash in the end if they have comparable sales and the royalty rates are comparable. It's more for show than anything else. So that happens sometimes in cross-licensing considerations. Other times it works in just the reverse. And this is more with smaller companies, where one company has a patent that they're really proud of and they don't want anybody else to enter the marketplace. The other company has a product and a patent that they're really proud of and they don't want anybody else to enter the marketplace. It violates the antitrust laws for the two to get together and say, we won't license anybody but each other. You're not supposed to do that generally. So what they do is they say, if there's another infringer out there, I would like to have an established royalty under my patent that's very large so that I can get a very large damage claim against them. Because I will have established through this actual license that I've entered into a high dollar value for my royalty or high percentage value for my royalty. So when they infringe, I'll be able to get huge damages from them and discourage them from competing with me. So both sides inflate their royalty, and if they both have somewhat comparable sales, that too will be a wash. So you don't have a real economic arm's length issue, but it looks to the world as though these patents are really worth a lot. And they're writing the same size checks back and forth to each other, so they're happy. They had to get a license from each other because they both were using one another's patents, but they really don't want anybody else in the marketplace. And if anybody else does come in, they would like them to be faced with very large royalty rates that they would have to pay under both patents. And so sometimes in cross-licensing, the royalty rates go up from what pure economic analysis might be, and sometimes in cross-licensing, they're depressed from what they might be. So you have to be very careful with regard to cross-licensing in not being fooled into thinking that that's really an arm's length transaction for the dollar value of the royalty or for the percentage of the royalty. There are all kinds of variations that people do from time to time. Most often it's a straight royalty through the life of the patent or a straight number of dollars per unit for the life of the patent. But sometimes the royalties will change with either volume or time. There are all kinds of analyses that go into that. Sometimes in order for the manufacturer to justify getting into the product at all, they need a low upfront cost. So you might have a very low royalty for the first 3 years, and then if it doesn't work, they're not out very much. Sometimes the patent owner says, I'd be happy with $1 million. That's all I want out of this thing. And you say, okay, we'll start out with a royalty of 5%, and when you reach $1 million, our royalty payments will stop. That's a deal. And that's really plummeting down once you've reached that threshold. Dealing with a license right now, just this week, who had that provision. The royalty lasted for a certain time, and sometime during this week, the royalty goes from X to 0. And the licensee is really happy now. It's my client, who can go on making the product without paying any royalties in the future because he's paid the quantity that the licensor wanted to have. If the license is going to be exclusive, then there's a whole other set of criteria that go along with it. If the license is non-exclusive, it's very rare to have any upfront money or any minimum yearly sales or minimum royalties required. Because it's non-exclusive. You can license other people. You don't really care whether that particular licensee does anything with your invention or not. But if it's exclusive, you really care that that specific licensee that you've chosen does his job. He owes it to you. Your patent is held hostage for his performance under that. And so, generally speaking, for exclusive licensees, there's some kind of an upfront payment, and there are also minimum either sales required or royalties required every year. And if you fail to meet those, either the license can terminate if you want to have that, or sometimes the license converts to a non-exclusive if they fail to meet that. In the licensing agreement, you can consider other things. The cost of litigation, who's going to control the litigation. These are really difficult points because the litigation is so very expensive. Does the licensor have a duty to assert his patent? Does the licensee have the right to stop paying royalties if there's an infringer out there? Generally, that's not the case, but there are some agreements where that is the case. Who pays the legal fees? Can the legal fees be deducted from the royalties if the license if the exclusive licensee has the right to sue. Who has the right to settle is a question. Who collects the damages against an infringer if the case is won? The right to terminate is almost universally on the part of the licensee. The right lasts until the life of the patent ends, or if there are several patents, until the last of the patent ends. Sometimes the licensee has the right to terminate, and if there's a material breach, if the people owe royalties and aren't paying the royalties, then you have the right to terminate, but for cause only. Generally speaking, when you grant a license under a patent, it lasts for the life of the patent. Oftentimes the license carries with it a duty to mark the products with the patent number, and oftentimes, occasionally actually, the patent will be for less than the full territory of the license. You can sell widgets on the east side of the Mississippi River, and I'll license somebody else to sell widgets on the west side of the Mississippi River. Okay, now we're going to go through a specific example that has real numbers, so you can see exactly how to calculate. Suppose you've just invented the doorstop shown on the right. Your friends tell you it's a clever device. Simple to make by bending boron-containing spring steel wire, and requires no tools to install. You conclude that if it had been invented by another earlier, you would have seen it in the stores. Moreover, it can be colored with decorator colors and can also function as a paperweight. So we have a multifunctional invention, doorstop / paperweight. Your marketing expert says there are 13.4 billion doors in the world with hinges suitable for use with your invention. He thinks at a minimum you could get 0.1% of that market. If so, you would sell 13.4 million units, not counting purchases for use as a paperweight. You estimate that in quantity you can make and package the doorstop for a dime and sell it wholesale for 25 cents for a 50-cent suggested retail price. Your mother says she would buy them for half of her doors, and you calculate that if that holds true for everyone else, your sales would be 6.7 billion units worldwide. You are convinced that this invention has a chance to provide for your financial independence, but only if you can get good patent claims for it and a suitable license. Okay, so we've come up with this great idea, but the key as to whether or not you can get a royalty of any consequence is what patent claims you got. So let's look. Well, let's first consider trade secrets. This product is going to be sold on the shelves. A person could pick it up and look at it, and it wouldn't be very hard for them to duplicate a similar product. They may not know that it contains boron in the steel, but for a few dollars they could have an assay done and they could tell you exactly what's in that steel, and they could duplicate that product very simply. So there's really not much in the way of trade secrets that are apparent for this product. So you've got some fixed dollar amount, what it would take to come up with the reverse engineered drawings. And you divide that by 3, and so maybe one lump sum payment of $5,000 for all the trade secrets is about all that's worth. So trade secrets doesn't really give you financial independence. It's not going to really work for this particular product. But now we look at the patent claims, and that's really the key. What claims did you get on this doorstop when you went to the patent office? If the only claim you got is a boron-containing spring steel wire, that's a nice claim for a spring steel wire. If other people want to use boron-containing spring steel wire, that's fine. But it isn't really going to do much to protect the doorstop business. If the boron-free wire, if a boron-free wire would work just as well as one that contained boron, then your invention is worth very little. There is value only in product distinctiveness. You can market it as a boron-containing spring steel wire doorstop, and nobody else could use that marketing. But if anybody was smart, they'd know that it didn't make any difference that boron was in there. But at least you would have some distinctiveness in marketing. And so it might be worth a little bit for that marketing edge, but certainly not enough, again, for your financial independence. So if that's your only claim, then you're sort of out of luck for this particular product. Now, if, on the other hand, your claim was a doorstop that hooks over one hinge plate of a pair to position a spacing member between the pair, that's a much broader claim. Doesn't specify the material that it's made from. It goes right to the heart of the functioning of the invention. And if there's no prior art out there that invalidates that claim, then you can have value. Particularly if the best and closest prior art is a doorstop retained by a hinge pin. That prior art would be more expensive to make because you have to put the hole in it for the hinge pin to go through, and more difficult to install because hinge pins don't always come out easily. So it is not as good of an invention as your invention. So now we have something we can talk about. We have a patent claim that actually provides an advantage over the best prior art. And so what do? We determine a reasonable royalty. We estimate the economic advantage and assign a third of that. Now, if we assign numbers to these, if the best alternative, the hinge pin retained doorstop, provides for a 12-cent profit per stop, and your patented one can sell equally well for a 15-cent profit per stop, that would suggest about a penny per unit for the patent owner, a third of the difference between the two profits. Okay, so we have a penny, and we're selling it at 25 cents wholesale. That's a 4% royalty. We convert to the royalty. And that would provide $134,000 according to our projected sales. Second step, take the preliminary royalty rate and adjust. Adjust upwardly if the license is to be exclusive, preventing you from licensing anybody else. You might increase it by 40%, multiply times 1.4, and it might go up then to 5.6%. And if it is going to be exclusive, then you want to have an initial payment, either as an advance on first-year royalty or as in payment of in addition to royalties, such as half the first-year projected royalty. So you might have an upfront payment from the licensee of $93,800, which is basically half the projected first-year royalties. And there would be a requirement for minimum annual payments or minimum annual sales, such as half the projected royalty amount. And then if they fail to sell at least $93,800 per year in any 1 year, then the license either would terminate or you could have a provision that it would revert to a non-exclusive. Then you can adjust downwardly if there's a cross-license involved, or upwardly, depending on the circumstance. Adjust downwardly if the patent has special risks of invalidity. And you can adjust based upon industry practices, if any, and adjust if the party has a special need to do a deal, just as we discussed before. A lot of times licenses have what are referred to as most favored nations clauses. Some licenses provide that the licensee shall have an option to convert to improved terms whenever any later license is granted with more favorable terms, such as a lower royalty rate. The parties to any license can always seek to renegotiate terms if business conditions warrant, although the other party may choose not to. That's something to keep in mind. You sign this license agreement, and the license agreement is for the term of the patent, and you're thinking, well, we're done. That's fixed now for the term of the patent. It isn't. The business conditions can change, and it may well be that the licensee says, I agreed to the 10% royalty, but I just can't compete at 10%. I got to have it lowered to 5%. The market conditions have changed. When I signed this, I thought it would work, and it's just not going to work at 10%. You got to renegotiate, or I'm going to drop the product. And so just because you sign an agreement for a particular royalty doesn't mean that it's necessarily going to stick there for the life of the license.
What kind of tax rates money you make off of royalties? Like, could you sustain yourself off of, $134,000 a year? Is it taxed at such a high percentage that it wouldn't actually be?
Well, it's income, whatever your income tax rate.
Okay, so
yes.
It's just normal income.
It's ordinary income. If the license is an exclusive license, you can sometimes characterize that as capital gains and get capital gains treatment. For non-exclusive licenses, that's generally ordinary income. Okay, the third step is finding a licensee. This is all well and good to talk about the calculations, but you actually have to find a licensee. And that's actually the hardest part of all of this. First, you can consider a company that's in a related business where the invention would be complemented by the products the company makes. A hinge manufacturer that doesn't currently make doorstops might really be interested in adding a doorstop to round out its array of products. Generally, you should avoid invention development companies that you might see on late night television. They have a very poor track record. Where the prospective licensee already makes doorstops, the license might be seen as a threat to its current production. So they might be a little bit less interested in your invention. But they do have all the avenues to sell their products, and so you're sort of forced to at least consider them because they have access to the markets for doorstops. You can consider contract manufacturing, where you do not license, but you contract to have the product made for you to sell, and then you set up a website to sell this stuff over the internet, or you just go to the major hardware stores and see if you can sell direct to them from the contract manufacturer that you have make the product for you. And so you don't actually own any equipment to make the product. You don't even have any inventory. You don't have any employees. You have what is referred to as a virtual company. And we've had some very successful clients with virtual companies who have made a very large amount of money with very little or no capital involved. It's a very good approach where you maintain control and license through your virtual company. And lastly, consider starting your own company. Forgetting the licensing process, and generally speaking, starting your own company has the greatest amount of potential. It has the greatest amount of potential for the reason that when you're actually building these things, you'll actually see ways to make it better. When you're actually selling the product to the customers, you'll get the feedback as to what it is that you could do to make it work better that you might not get in some of these other approaches. And so you can have a continually evolving and improving product over time. And that's really what tends to make starting your own company, apart from the fact that you have a lot more control, the greatest potential for profit. Lastly, don't be overly concerned that someone will steal your invention. It may be the best thing that could happen to you. If you remember at the beginning of this slide, we say finding a licensee is the hardest part. Imagine somebody coming along, taking your invention, and marketing it for you. Now, obviously, they're going to try to pocket all the money. But I can tell you, it's the same thing as being in a subdivision where you buy a lot. And people are building houses all around, and you drive through one day, and you see somebody building a house on your lot that you've purchased. Now, I'd like to ask you, can you sell your lot to that person that has already started his house for more money than you could if it had just been an empty lot? Do you have a captive purchaser there who will negotiate with you whether he likes it or not? So it's really to your advantage if somebody steals your invention. Now, you can't say, go ahead and use my invention, because then you've just given him a royalty-free license. But if it happens that somebody steals your invention, I can tell you that juries are not very pleased with those people, and they tend to award very large amounts of damages. And so your leverage is very high when you go to negotiate with them as to what the consequence would be. So there you go. Now you know everything you need to know about licensing. We'll talk about litigation next time.